Good morning.
Morning, my lords. Please, your lordships, may I dispense with introductions since you had written submissions from everyone, or would you like me to do a roll call?
Well, I think we sort of recognise most of the assembled stars of stage and screen. But I tell you what would be helpful to me, at least, is to understand what the undertakings are that are represented before the court. And I'm not talking here about the CMA, but there seem to be four groups. And as I understand it, but I may be completely wrong, because I'm the new boy to all this, but as I understand it, and I'm just reading from my own notes, Allergan owns Auden, and Sinven owns Advance. Is that right?
Oh, yes. Sinven until October 2015 used to own.
Doesn't anymore.
Oh, no.
My Lord Allergan used to own Activists, which owned Auden, but hasn't done since August of 2016. So that's how.
So what is the separate interests that everybody has that is going to lead to 45 pages of skeleton arguments from four different groups in this case?
Well, my lord, we say on the CMA's appeal, there are no separate interests, because the CMA's appeal is about what the tribunal's called the due process issue. And it may be helpful. May I just say something for a moment or two? So,
well, why don't you do that? Let me just say this.
Yes.
Since everybody has agreed that you should have permission to appeal
Yes.
on all your three grounds, you have it.
I'm most grateful for that, my lords. And so I think what I need to address really is the shape of the hearing and the additional points that the respondents say that they wish to run. And may I just say this at the outset, there is a distinction between the CMA's appeal against Hydrocortisone 3, which relates to the due process issue, which is a procedural, all three grounds are procedural grounds. And the various points, and of course it goes without saying that the respondents can raise whatever arguments they want in relation to the CMA's appeal, in relation to that. And their interests, as I apprehend those interests, are not, they're completely aligned.
They should be completely aligned.
They should be.
Well,
And on the rest of it, as I understand it, any appeal from Hydrocortisone 1 is stayed by agreement. And presumably, is the same true of Hydrocortisone 2?
So, my lord, I think, so Hydrocortisone 1 relates to the abuse of dominance.
Yes.
And I think everybody's agreed that no appeals have been brought yet in relation to that.
No.
And everybody agrees, as I understand it, that any appeals that may be brought should not be heard with the CMA's appeal against Hydro 3. So that's point one. Hydro 4 relates to penalty. And because that's a subsequent matter, then, as I apprehend it, everybody agrees that any appeals which have not yet been brought against Hydrocortisone 4 on penalty should await the CMA's appeal on Hydrocortisone 3. The area of debate relates to Hydrocortisone 2. So my learned friends have said in their submissions that they wish to raise various points against Hydrocortisone 2. And the way that arises is this, because we've said in our appeal against Hydrocortisone 3 that if we are successful in that appeal, so if we're right to say that there was no failing of due process...
And the rubric comes off Hydrocortisone 2.
That's right. And the decision is reinstated. And
They say...
We say. And my learned friends say, no, not so fast, because we've got points of appeal against Hydrocortisone 2. So...
But why is the point not? And somewhere, I believe, the tribunal said that there was to be no appeal against 1 or 2, and I think 3, they said, until 4. But now there has been 4, so there can be. But can we not say that appeals against 1 and 2 should be separate from this expedited appeal against 3?
My Lord, yes, and that is the position that the CMA would urge the court to adopt. And in a nutshell, I'm going to take the court briefly to our appeal and then show you why the points that my learned friends wish to make on hydrocortisone 2 are severable. That's
should be dealt with if but only, well, not if but only, if and even if not, you succeed.
Exactly. And so, my Lord, so we entirely accept that if we succeed on hydrocortisone 3, the court would not at the end. So we are, first of all, grateful that the court has set aside 2.5 days to hear that appeal in July. And if we succeed on that appeal, we accept that the court, in its judgment, will not be able to say, it will be able to say the CMA's appeal is allowed, but it will not be able to say the decision is reinstated until it's determined any appeals, should they get permission, in relation to hydrocortisone 2. But as my Lord, you've said, it's correct, hydrocortisone 2 only revives, at the moment it's been retracted by the tribunal, as you've seen. It only revives if we're right on our appeal in relation to hydrocortisone 3. So we do say that that is the appropriate way of managing this, that hydrocortisone 3 should be expedited. And we say it should be expedited because it raises an immensely significant point which bears heavily upon the ongoing enforcement work of the CMA. And the reason we say that is because the CMA has long proceeded on the basis that it can establish that agreements of this nature infringe competition law without proving dishonesty on the part of any particular individual.
Or intention.
Or intention. And also without establishing that the meeting of minds, which the CMA needs to establish, took a particular form or contained a particular form of words. And so that's yet the basis for the tribunal's due process findings is that the CMA was not entitled to proceed on that basis.
Well, classically, a covert infringement, by definition, is going to be very difficult to say who said what to whom. So you're drawing inferences, and you know, reading hydrocortisone 2, especially apart from the due process point, the last sort of 10 pages, from about page 80 to about page 90, they seem to have taken on board. The cat seems to have taken on board all these points.
My Lord, exactly so. And so the reason
but just
why...
before you
Yes.
go on, I mean, is it contested that the appeals against hydrocortisone 2 should be entirely separate from the appeal that you are bringing against hydrocortisone 3, with the ability for the respondents to serve respondents' notices in respect of the reasoning in hydrocortisone 3? Is that contested?
Well, I think it is from their submissions, and that's what I was going to take you through our appeal, and then...
Well, put like that, is it contested by everybody?
Yes.
Yes. Okay, good. I mean, it's fine. I don't mind. You're allowed to contest whatever you want. But and I would suggest then that we address that first, don't we? Before we come to directions, it may be sensible for us to hear argument from everybody on that first, because it may affect directions. Well, it will affect directions.
My Lord, absolutely. So may I make our submissions on that?
You may.
Sure.
Thank you. But we agree that is, with respect, that's the key point. And could I first of all say something about the CMA's appeal? And if you could take up the core bundle, tab 4A, this is hydrocortisone 3, and turn to page 85 of the bundle. And if you look at the bottom of the page, paragraph...
Sorry, I just need to have the right one. This is the core...
This is the core bundle behind tab 4A, and it's page 85 of the bundle. So it's the hydrocortisone...
3.
So it's paragraph 14.3.
It's hydrocortisone 3.
Hydrocortisone 3, page 85 of the bundle behind tab 4A.
Could you just give the paragraph numbers in hydrocortisone 3?
14.3.
Thank you.
In fact, let's start with 14.1. So 14.1, the judgment cartel infringement, so that's hydrocortisone 2, upheld the findings of cartel infringement in the hydrocortisone decision and found that all of the grounds of appeal failed. Nevertheless, these conclusions were expressed to be provisional because of a concern expressly articulated in Hydro 2 that the CMA's conduct of the proceedings had so fundamentally failed to observe certain requirements of due process that the provisional conclusions on the judgment could not, as a matter of natural justice, stand. And then at 14.2, subject to the point of due process that's the subject matter of this judgment, Hydrocortisone 2 makes findings of fact from which we do not consider ourselves able to depart. If on an appeal this judgment is overturned, then assuming no other successful appeals on other points, Hydrocortisone 2 would stand as the factual basis for the determination of the appeals. That's the point that I've made to you already, and we accept that you would not be able finally to decide that so until you've heard any appeals in relation to Hydrocortisone 2. And then at 14.3...
So we would just find that Hydrocortisone 2 stood subject to appeals.
Yes.
It's been retracted at the moment. What does that mean?
Well, it's a very good question. It's a very odd process, but what it appears to mean, and our ground one, which you've granted us permission to run, is that the tribunal had no jurisdiction to retract its findings in that way. So it's a very odd state of affairs, but what the tribunal appears to think it means is that its findings stand on Hydro 2, on the decision, upholding the decision, if it's wrong on due process.
So we reinstate that always subject to appeal.
Absolutely. And I think that's probably common ground, that they would need, the respondents would need successfully to appeal Hydrocortisone 2 in order to escape a reinstatement of the decision.
So how can they do that without an appeal and getting permission to appeal?
Yes.
The judgment in H2 when they are defending a judgment in H1, H3.
H3. Sorry, H1 is completely,
No.
push that away. So H3.
Sorry.
So you're right, my lord. They need to seek permission to appeal H2, which they haven't done yet. And you'll see from Sinvan's skeleton argument for this that they say, well, we should now be allowed to seek permission from the tribunal. We've got until, I think it's the 20th of May or so in order to do that. And their suggestion, which we say is completely unworkable, is that they should be able to take any points they want in relation to Hydro 2, and permission should be rolled up to be heard at the 2.5-day hearing in July. And we say that would effectively torpedo the hearing. So we say that can't happen because they haven't even identified what their points are.
It sounds like a recipe for confusion.
Absolutely. And so we say that the proper way forward is to separate off their appeals on Hydro 2. They'll have to seek permission. We'll then have to see what they get permission for. The CMA may wish to put in a respondent's notice in relation to Hydro 2. All of that will have to evolve.
So what is the best course for us to hear what they have to say? Because, we have read the material. We understand your grounds of appeal. We understand how they separate out. And what we have not seen is the points they want to raise in resisting your appeal. So it might be best to hear from them. And I'd like to know the order in which they intend to speak and how many different arguments are going to be advanced. Because as I understand it, I won't even say how I understand it.
My lord, I'm very happy to sit down. May I just flag one point, which is this, that some of the respondents, so for example, Auden does this, says, well, these are respondents' notice points we would wish to take. But they're not actually respondents' notice points. A respondent's notice point in relation to the CMA's appeal would be a point going to due process.
We're preeminently well suited to understand.
Of course you are, my lord. I'm going to now sit down. I'm going to sit down. Thank you.
Thank you, Mr. Meekley. Now,
shall I just...
Yes, by all means.
Mark Brealey.
Yes. But Mr. Brealey, I'm slightly surprised to see you standing up first. So tell me why you're doing that.
Well, advance were my witnesses, but I don't have to stand
Advance
up.
were so the witnesses are yours.
Yes.
So that's your claim
Advance
to fame.
is the key player, really.
Okay. So does
that's
everybody
why I stood up,
acknowledge?
But I can sit down because essentially Mr. O'Donoghue has more to say about H2 than I did in my skeleton. So I do need just to tease out some nuances about H2. But I, at the moment, have no respondent's notice before this court on H2.
But you need permission to appeal on H2.
Well,
You can't do it by way of a respondent's notice to a separate appeal, unless it's in the same, unless it's against the same judgment.
well,
the same order.
this is. Could I just very quickly go to our skeleton just to explain this point? So obviously this is at page 17.
Yeah.
Yep. So at paragraph 4, we say there are broadly two main issues that arise from the CMA's ground 2. I appreciate they're going to get permission now.
Just got to give me a minute
Sorry.
to find. I haven't got
Page
your,
18 of the.
I know, I haven't got your submissions in.
Um,
So this is advance
This is
written submissions for today's hearing.
Correct.
Paragraph what?
well, so at paragraph 4,
Yeah, broadly two main issues.
the first is whether the failure of due process undermined the findings in Hydrocortisone 2. So that's, as we say in paragraph 5, that is obvious. But the second issue is whether the CMA adduced sufficient proof to infer the unlawful agreement not to enter. Now, why do we say that? At 6, we say the second issue is very closely related to the first, but is wider because the Tribunal on Hydro 3 made certain findings which militate against the CMA's inference of an agreement not to enter the market. CMA in Grade 2 challenges various findings of the Tribunal, aside from due process, submitting, for example, that the Tribunal misunderstood a witness's evidence. So it's important for us to be able to show my lords why the CMA is wrong just to say, well, if we win on due process, then in some way this provisional H2 judgment can be reinstated. And we pick, so you'll have seen in our skeleton at paragraph 7, we outline what we consider.
So what I don't understand is why we can't say that the due process allegations that are made by Mr. Demetriou against what the tribunal did in Hydrocortisone 3 is swept aside, leaving you with an absolute right to say whatever you want in getting permission to appeal against 2, which would enable you to say whether the CMA adduced sufficient proof to infer the unlawful agreement not to enter the market or not. Why can't that be said? What's that?
But it's just simply because it's all part and parcel of the CMA's ground 2B.
Well, it may be part and parcel, I understood. It may be the same, it may be a related point, let's put it that way. But that doesn't mean that it is necessary to rehearse it in order to decide their ground 2.
I fully understand that, and you'll have seen from our skeleton, we concentrate on H3. What we are just concerned with is that there's a false economy here.
Oh, I see. You're concerned with our time.
Well, I'm concerned
That I appreciate.
we're going to come
Always
back.
appreciate.
But it's just a false economy that we could be arguing some of the points in response to the CMA's case in ground 2B in July, whereas if we push it back to another day, it's just a false economy.
You see, my problem is that it does strike me that this is a very unusual, Mr. Demetriou appeal is a very unusual appeal.
Yes.
And it raises points of principle, which I feel this court needs to look at quite quickly.
Yes, I understand.
And they're not quite the same as what one might call the sort of technical competitionary points that might come up in contesting bits of H1 and bits of H2. And I think as a matter of good case management, even if there's going to be a bit of overlap, my disposition would be to decide whether Mr. Dimitri is right or wrong on H3
Yes.
before we start getting in to the detail of H2 or
I fully understand, and our skeleton is focused on H3.
Yes.
But can I just, so that the court has the full picture, if one looks at how we have defined due process for paragraph 7, we say what the tribunal did in H3 was identify essentially 3 deficiencies. The first was to put the allegation of serious misconduct, dishonesty, to the witnesses. Now, we're obviously going to argue that, whether it is all part, everybody knows it's not a necessary condition for an infringement. In the circumstance of this case, it may well be. Then, the second is the failure properly to articulate what the alleged agreement not to enter was. Now, that is something that the tribunal on H3 said, we still are unclear what the unlawful agreement was. Now, that is also in H2. So, but then if one then goes to the third bullet, and now this is really why I just want to make it crystal clear. The third was the failure to challenge material evidence given by the witnesses. So this is not just the CMA not putting its case in the decision to the witnesses, the dishonesty and the misleading. This is essentially a more general point, a more common law point, about the failure to challenge material evidence given by the witnesses. So when, for example, paragraph 145 of H3, and then I'll let.
So 145 of what?
Of H3.
Oh, the judgment.
Judgment.
Which paragraph? 145.
145.
Yeah.
It's at page 91 of the judgment.
Sub
paragraph 4. Now this is relating to the first, second, third bullet points of paragraph 7, but it's in particular, we need to recognise, we haven't got time today to go through it all, the failure to challenge material evidence given by the witnesses. When the tribunal H3 at 145, subparagraph 4, says, without cross-examination of this version of events, neither the CMA nor this tribunal can properly disbelieve them and hold against the appellants. Now, this is important because in H3, and again, we try to set it out in the current stance.
because you said they did disbelieve them in H2.
They
They
did disbelieve in H2 on the record that they said they had, but they wanted to work out whether the failure to challenge material evidence made an impact. Now, to cut a long story short.
So why don't we decide whether or not Mr. Dimitriou's challenge is correct? In other words, that they should not, for one of the 3 reasons she gives, have done what they did in terms of adding an embargo or a condition to their judgment. They should simply have just released the judgment, and then you can appeal it and say all the things you want to say about challenging witnesses later.
The only I push back against that is because we have a clear
It's connected.
finding in H3 that I, the tribunal, are not prepared to draw the inferences. In H2, I didn't have a complete record. I wanted further argument as to whether material was properly put to the witnesses. I'm now satisfied that it wasn't, and I am not prepared to draw the inference that I made in H2.
But instead...
But hang on a moment, because if that premise is wrong, then so is the failure to draw the inference. In other words, H3 will go in its entirety if Mr. Dimitriou is right, including the doubt that's being expressed here, which is inconsistent with what the tribunal had said in H2, very clearly finding that on the basis of what were able to infer there was an unlawful agreement, which went beyond the written agreement. So, well, at the moment I'm puzzled as to what it is you're seeking to achieve that isn't properly dealt with by way, in due course, of an appeal against H2. But anyway.
And if you win, of course, then you win.
Yeah.
If Mr. Dimitriou's appeal fails, then you've won full stop.
Right.
I'll let others talk, but I just want this court to realise that that there are findings in H3. So, for example, in H2 they infer an infringement because of the undervalue, the purchase price. But in H3 they say, well, I'm not prepared to draw that adverse inference because.
But what I mean, I get all that.
Yeah.
Really do get all that. But what I think you're sort of, if I may say so, glossing over, is that Mr. Dimitriou's challenge is to the entire process of doing what they did in the 2 bites. She's saying, you can't do that. You've made findings, and it was not appropriate to undo those findings on the basis you did. Now, if it was appropriate to do that, then you'll have, as my Lord says, you'll have won anyway. And if it wasn't appropriate to do it that way, but was appropriate to do it at an earlier stage, you'll win on your second bite of the cherry when H2 is appealed. So you're not going to be disadvantaged by the bifurcation, as I see it at the moment, because you'll have your opportunity. But I do get your point that there will be a certain amount of overlap in the argument.
Yes, and that's all I was trying to.
Yeah.
So when if one looks at the third bullet point in paragraph 7,
Yeah.
and which is so we've done dishonesty, we've done the failure to distinguish between the lawful and the unlawful, and then we get the failure to put material to the witnesses, and the tribunal in H3 saying, well, as a result of that, I'm not prepared to disbelieve Mr. Baton. I called him basically a liar in H2. I'm now not prepared to disbelieve him. At what stage do we make that point? Now, it may well be that we'll have to make that point after July, but my simple submission is the tribunal says in H2 Mr. Baton was a liar. The paragraph I've just showed you says I'm not prepared to disbelieve him. It all seems to be very closely connected.
No, I get that. I mean, I think that's your bull point. Yeah. That if we all had endless time and perhaps money, we would look at all these 3 judgments in full meticulous detail together and deal with every point that could be made. And Mr. Dimitriou is asking us to do it in 2 bites. And at the moment, as we've said to you, we're quite attracted to that.
Oh, I understand that.
But let me hear what the others say, and then we'll also hear what. But you've made very strongly the point that there is significant overlap, and maybe therefore double argument, because you're going to have to raise the same argument. Okay, who's now going to go next? Mr. O'Donoghue, you're looking keen. Mr.
My Lord, we've identified 2 points that we say are so inextricably entangled with the CMA's appeal that it wouldn't be appropriate to hear them separately. The core of the CMA's appeal is that it did put its case sufficiently to advance its witnesses because it seeks to distance itself from a series of elements the tribunal relied on and the tribunal considered formed part of the CMA's case. And in our submission, that raises a very immediate question.
Sorry, can you say that again? I don't think I quite got the full.
I'm sorry, my Lord. The core of the CMA's appeal is to say we did put our case sufficiently to advance witnesses. The reason they're able to say that is because they seek to discern a series of additional elements that the tribunal relied on in Hydrocortisone 2 to uphold a finding of infringement.
Yeah.
In our submission, that raises a very immediate question, which is, once all those elements have been discarded, does the CMA have enough left to establish an infringement of Article 101? And our submission will be that the answer to that question is no. There is insufficient left to demonstrate an infringement. So, as the court is aware, the CMA are saying that if they succeeded their appeal, then the decision should be upheld because the tribunal was able to find an infringement in Hydrocortisone 2. But the tribunal in Hydrocortisone 2 went way beyond the CMA's case.
That's a point for appeal against Hydrocortisone 2. You could say, in due course, that the CAP went beyond the CMA's case, and that was unfair.
My Lord, we say that it does come back to Hydrocortisone 3 as well. And the reason for that is that what the tribunal has done in upholding an infringement on the basis which is not in the decision and which was not part of the CMA's appeal is to go beyond the permissible scope of appeal on the merits.
I understand the point you make, but I'm just querying whether it's really a point for the hearing in July as opposed to a point for the future.
Well, my Lord, in our submission, it is properly a respondent's notice point. It is a reason why we would say this court should uphold the tribunal's decision to grant the appeals on the Article 101 infringement for reasons which are different than those given by the tribunal. But the interconnection goes further because one of the reasons as to why this was not properly open to the tribunal is because it goes beyond the scope of an appeal on the merits if it starts to infringe on questions of due process. And we would say it does indeed give rise to problems of due process if the tribunal relies on factors which the CMA, by definition, in its appeal, is saying we don't rely on these factors, and therefore, by definition, they were not put to the witnesses, because the CMA is saying we absolutely disavow that this element of the case actually forms any part of our finding of infringement. That, in our submission, is one reason why one would say it's not open to the tribunal on an appeal on the merits to make these findings. They certainly, the CMA's positive case that they were not put to the witnesses because the CMA says it's no part of our case, and so we say these are
But that's an
massively
attack on
intangible.
that's an attack on H2, isn't it? That's saying that in H2 they've gone beyond what even the CMA was saying the position was.
But is that right? That a tribunal is not permitted to look at the matter a different way from either of the parties?
My Lord,
I mean, I know you put it in the more strident way. You say, well, they've gone beyond and it's completely impossible that this was... But when a case is, a complex case is carefully argued between the parties, does the tribunal have to decide for something that is said specifically by each side? Can it not say, I've seen the evidence and it seems that this is actually a middle or different position is in fact the reality that we're finding for?
My Lord, I have in mind paragraph 141 of my Lord Justice Green's judgment in Flynn Pfizer, where he said that the tribunal's merits appeal takes the decision as its starting, middle and end point. Now, in this case, the CMA's positive case on this appeal is this was not in the decision, this is not part of our case. And that, in our submission, is a fairly extreme example, where in those circumstances it's not open to the tribunal to say, well, I see that you're disavowing this as being any part of your case, but nevertheless, I'm going to purport to supplement your case. I'm going to make findings that are not advocated on behalf of the CMA.
Is that the Flynn case in which we were both in? Yes.
It's an attack on both of us.
I fear it may be.
But I mean, well, we could, I don't think we ought to reinterpret or interpret what we said in that case now, certainly as after. Can I just make sure I understand precisely the structure of the appeal? The first point is essentially a point of law. The tribunal in paragraph 16 and 151 said that dishonesty is no part of the test. Yet it then went on and said dishonesty and intention is part of the test. And that's why it then went into the second hearing to see whether or not questions put in particular to Mr. Baton were sufficient. But if it was wrong on the first ground, In other words, that it somehow concludes that dishonesty and intention are relevant matters which it disavowed elsewhere in the judgment. Nothing, the second part of Mr. Mitriu's appeal doesn't arise. Just, it should never have gone into H3 at all. It was just forbidden territory. It went in on a false premise. If you get there, then all that we have in H3, and which is being challenged in what paragraphs 88 onwards of CMA skeleton, is focuses upon whether the questions put to the witness were adequate. It's not really whether the answers were correct or not correct. That might be for the substantive appeal. What I'm struggling with is why any analysis of the substantive merits is relevant, as opposed to, first of all, point of law, dishonesty intention, is that relevant? Secondly, in any event, were the questions put appropriate? And we come to a conclusion, we either reinstate the original decision or we don't.
Well, it's important to appreciate it's not only a question of dishonesty or not dishonesty. That is one of the elements in relation to which the CMA say that's no part of our case, but it's by no means the only one. They also say, for example, we don't accept that one has to look for a separate side agreement. They also say we don't accept that one has to in any way infer a particular communication in order to find an agreement contrary to Article 101. And that point in particular is a very striking example where the tribunal goes a long way beyond what the CMA did. So if the court could please look at paragraph 144.
Is that a point about the merits?
It's a point. It's a point about the extent to which anything could survive in hydrocortisone. If the CMA is right that it put only an extraordinarily limited case, how then can hydrocortisone 2, which relies on findings that the CMA itself disavow, essentially be resurrected and reinstated?
We find in favour of the CMA upon their appeal. We reinstate the decision, or we then consider what we do, but assuming it's reinstated warts and all, adequacies or inadequacies, subject to appeal, in which case you can say, okay, it now stands. It's nonsense because.
In my submission, one cannot reinstate the decision in circumstances where the basis on which the decision was upheld is a basis that the CMA expressly says was no part of our case. It does not automatically follow that the decision resurrects itself if it's been upheld by the tribunal on a basis the CMA seeks to say.
But that's why I asked you the question a while ago. That point is a point that should be perfectly open to you to take by way of appeal against Hydrocortisone 2, if Mr. Mitriu's appeal against Hydrocortisone 3 succeeds. Because the effect of her appeal against Hydrocortisone 3 is it just goes. It should never have happened. So you go back to Hydrocortisone 2 and you excise all the stuff about due process. But the argument as to who said what to whom and whether the case that was found by the CAT is a different case from the CMA's case will be open to you on appeal.
Can I just add a different question that you can answer, my lord, as well? What do you say would be added to the H3 appeal if you have your way and you're allowed to bring, by way of respondent's notice, points that challenge the H2 decision?
We've identified 2 points. The first is, and we say both of those points concern the overall question of what it is the CMA has to show to uphold a finding of infringement. And so they have that commonality about them. The first would be that...
Are these in your skeleton?
My lord, yes they are. So we've identified the respondent's notice 1 and 2.
Can you just give me the paragraph number?
Yes, ours would be tab 5 of the submissions bundle, and then the...
Tab 5.
So respondent's notice point 1 is defined on page 2, paragraph 10.
Sorry, I think we're looking at syndrome.
I'm sorry, it's tab 5 in the bundle I have, but...
No, I think we've got a differently organised bundle.
Mr. Mitri was telling me it might maybe tab 10.
Tab 10, page 249 of the bundle. Which paragraph?
Paragraph 10,
Yeah.
and we've defined respondents notice point 1,
Yeah.
and that would be the point that I've just been developing,
Articulating,
which
yes.
is, in our submission, it's the other side of the coin of the CMA's appeal, because if the CMA's appeal entails saying these elements did not form part of our case, so we did not have to put them, the other side of the coin is to say, well, insofar as the tribunal upheld your decision on bases which you now disavow, that goes beyond the scope of an appeal on the merits, both because the appeal on the merits takes as its starting and end point the decision, and also because one of the circumstances the case law tells us it will not be appropriate for the tribunal to essentially expand matters in an appeal on the merits is when it gives rise to issues of due process. And so we come straight back to this intertangled question of what properly should have been put to these witnesses. And we say it's all fundamentally interrelated. That's the first point. The second point we've defined in paragraph 14 of our submissions. And this also concerns the underlying issue of what the CMA must show to define an infringement. But this concerns essentially the period when, just the subsequent period after the core finding of the tribunal, which was that it inferred an express communication between Auden activists and AMCO, which was no part of the CMA's case. Once it had done that, the question is, how could that communication, how could the effect of essentially the common understanding that the tribunal had inferred be passed to successors in title?
In other words, you can't carry over guilty knowledge.
Our submission will be, because of the nature of the common understanding one has to find, it's a meeting of minds between human actors. If that's what is required to show an infringement in the circumstances of this case, how on earth can that meeting of minds survive and be perpetuated when Auden is then acquired by Allergan on the 29th of May 2015, and the one individual that the tribunal has found had that requisite common understanding has left the company?
Okay.
Now, the tribunal has come up with what, in our submission, is a very novel notion that that knowledge can pass because of the concept of undertaking. And in our submission, that's simply wrong as a matter of law, and the concept of an undertaking gives the tribunal no answer to the question whether or not the human element of common understanding and meeting of minds is capable of being perpetuated when there is a corporate transfer.
So what does it add to it? So let's say you're entitled to bring those 2 points as respondents' notices, even if you require permission to appeal H2 at the same time. And how many days of extra argument will this necessitate? I'm assuming everybody's agreed 2.5 days is enough for Mr. Dimitri's appeal.
My Lord, yes, we have no objection to the very narrow points, but we do say these are heavily interrelated. My estimate is that I would require half a day to open on those 2 points, and so I would anticipate the CMA would wish to have half a day in order to respond to them.
So that's an extra day.
It would require an extra day.
Yes. And would that cover everything that everybody wants to appeal about H2?
I don't think Mr. Dimitri thinks it would. I don't think I do either, with respect. I mean, having read your respective skeletons, it seemed to me that one was looking at a 4 to 5 day case overall. Assuming everybody's allowed to say what they want to say, and that we don't have limits as to who can speak and how many pages they put in by way of skeleton, which is a different issue, which no doubt we'll come on to.
My Lord, yes, my estimate essentially deals with the 2 discrete points. That
You're just talking about your own point. And I'm going to look at that
Mr.
picture
Brealey's
overall.
got a point as well, which is not
No,
exactly the same.
I understand Ms. Ford's point. It's basically, is she liable for the fine point. As I've tried to emphasise, we've taken the CMA's grounds of appeal, and if we could just look at those grounds of appeal. So this is in their skeleton argument.
Yes.
So we actually know what we're dealing with. This is my folder 3 of 3. It's the skeleton argument in support of the grounds of appeal. page 56. So the first ground, ground A, this is paragraph 92 of the skeleton, paragraph 92 of the CMA skeleton. So the first ground is errors in treatment of the written agreements. So this is the CMA saying the CAT got it wrong in the way that it distinguished between the unlawful agreement and the lawful agreement. Then in ground 2B at 97, the CMA say there are errors in holding that the only evidential basis was the value transfer. And what I was trying to articulate earlier on, the passages in the judgment, is that is a question of inferring the infringement agreement. You see it, I've asked to it, the CMA's understanding of how this point feeds into the tribunal's overall conclusion is the tribunal means to emphasise that because the CMA's case rested entirely on an inference in one piece of evidence, it was all the more important. Yes, so it's all connected with cross-examination, but clearly, I mean, it's blindingly obvious that you've got to articulate the agreement first, the unlawful agreement, so it's put to the witnesses. We say there was always a confusion as to the nature of the agreement. Then we go on, and there's lots in this ground, which essentially goes beyond due process. There's 2C, paragraph 106, page 61 of the bundle, where the CMA says the tribunal committed errors regarding AMCO, that's Advances Communicating a Promise to Auden. So that's it's not just simply a question of putting questions to the witness. Then we have, it's a lot of this is obviously about putting questions to the witness, but there's always a prior question as to what the case is. And then we get at ground 2D, the CMA saying the CAT got it wrong on commercial rationale. Now again, that is the unchallenged evidence. The H2, the tribunal said, I'm going to infer from the very favourable purchase price. In H3, it says, when Mr. Baton gave evidence and said there was a commercial rationale for actually going in earlier, inconsistent with the infringing agreement, this is the issue that it goes to. And then, right at the end of the day, we have ground 2E, dishonesty. So I just simply do not want my lords to think that this is all about dishonesty, which is clearly a very, very important point. We know that intention, we know that dishonesty is not an essential condition for infringement. Was it important on the facts of this case? That is this ground. But there are lots of nuances in the CMA's other grounds where one is trying to articulate. So the first ground, errors in the treatment of the written agreement, that is a question of what was put to the witnesses.
Can I ask you, did you and Ms. Ford raise all the points you are now suggesting at Cortisone 3 at the hearing? Hydrocortisone 3. So when he directed, the tribunal directed the new hearing to talk about his concerns about what had been put to the witnesses, did you say, oh no, well actually your decision is completely unacceptable for the following 6 reasons, which you should also be concerned about? You didn't say that.
We have repeatedly, since the dawn of time, said that the CMA has never properly distinguished between the lawful agreement.
No, but I'm asking what you put to the tribunal when the tribunal raised its desire to abrogate its decision. So you get the decision in H2.
Yes.
And you look at it and you say, I don't like this for all sorts of reasons, because it's not clear what the CMA's case was. They've gone beyond the CMA's case. They've gone beyond the decision. all
Well,
terrible.
that's Miss Ford's point. But yes. I
Okay,
understand.
but you say, and you say what you say, and the tribunal gives you a lifeline and says, but we think this should be done away with if there wasn't a fair opportunity for the witnesses, your witnesses, to answer the question about dishonesty.
Yes. Well, it's not just a question
Not
of dishonesty,
just dishonesty.
but what the agreement was. So, for example, there
Well,
is... Yeah, that's okay.
Okay, but I think actually that's not what the tribunal said. The tribunal said that their concern was that the case had not been properly put, that they were not telling the truth in their witness statement. I've looked at the witness statement in which they say clearly there was no agreement, and they say that should have been put that they were lying,
Yes.
right? Which you do in a good common law court, right? Did you then say, but I think you didn't, there are all sorts of other problems with cortisone too.
We can go to the due process hearing. Mr. O'Donoghue and I said we divvied it up. I can give 100% certain. In fact, he's attached the due process submissions to his skeleton. 100% the tribunal was appraised of the failure to distinguish between the lawful and the unlawful, and that was prejudicial to the witnesses because the unlawful agreement was not properly put to them. Now that was raised at the due process hearing. That is why it is the first ground of appeal by the CMA. And I'm just concerned that I need to address these grounds of appeal. I have not argued for a respondent's notice. I just need to address what is in the CMA's grounds of appeal.
You're not saying you want to respond.
No.
You're saying you want to raise all sorts of...
Well,
you will be raising all sorts of ancillary matters in response to their...
Correct. And I just want it to be understood that dishonesty, very important point. There's a lot more to CMA's grounds of appeal than just dishonesty.
No, well, your point is it's the case wasn't properly put.
Correct.
Okay. Can we hear what you interrupted poor old Miss Ford?
Sorry.
She was, I don't know, in full flight, but
Sorry, my babe.
finish off your... I mean, we haven't got all that long, and so we're going to have to be fairly brisk. I think we've got the main points.
Your Lordship has the 2 points that we say are inextricably linked. To respond to your Lordship's question as to the extent to which that was canvassed with the tribunal below, we did first of all make the submission that our position throughout the appeals has been that the CMA's case is not sufficient to establish an infringement. It doesn't put matters high enough to get to the threshold of infringement. And we did say that the consequences of the procedural irregularity was that the tribunal's findings in Hydrocortisone 2 were irreparably tainted and so couldn't be permitted to stand. And so our approach was that the findings in 2 and the findings in 3 were essentially a totality, and that those in 2 couldn't stand in the light of what had occurred in the light of the procedural irregularities. So we made that global solution. We did not identify the 2 respondents' notice points in the degree of granularity that we have sought to do before this appeal, because, of course, this is an appeal court and the tribunal was simply dealing with matters that were essentially consequential to its judgment.
Yeah. Okay. Mr. O'Donoghue.
My Lord, Sidman has no objection whatsoever to the concept of doing this in 2 bites, and we think that that can be done in 2.5 days or 3 days, or the indication given. My Lord, our concern is a pragmatic but fundamental one. If we go back to the CMA skeleton, please, it's in tab 2-4. Now, the first point is at the very end, at 131, it's on page 72. The CMA originally invited the Court of Appeal to confirm the decision insofar as it relates to 10 milligram agreement. Now, that has been withdrawn by Mr. Dimitriou this morning. That's an important starting point. Now, if we then go back to the grounds you've seen in ground...
What did she withdraw?
She is not asking the Court of Appeal, at least at this stage, to confirm the CMA's decision insofar as it relates to the 10 milligram agreement, because she accepts.
Well, I mean, confirming it subject to an appeal.
Well, it's a rather big if.
But you haven't got permission to appeal anything yet, so.
Well, no, the deadline has not expired.
No, but I mean, even if you get permission to appeal, she's still entitled to confirm it subject to the success of any appeal. So
It's a rather big if in my submission.
Okay.
Now, Lord, to go back to the practical point, in ground 2, I mean, Mr. Breedy has shown you the terrain in broad terms, but if one looks at grounds 2A to 2E, so 2A is the written agreements, 2B is the evidential basis, and your Lordships will see, for example, at page 59, or just above 105, other evidence relied upon by the CMA, and you will then see the sub-bullets, supply price, 20 milligram agreement, inferences, AMCO understood, 9 separate evidential points, 2C, evidence relating to a promise to Auden, then 2D, and 2 dishonesty. Now, our practical concern is, what the CMA is essentially inviting you to do here is it has selected certain cherries from Hydrocortisone 2 and 3 that it wants to rely on in the context of this due process appeal. And our only pragmatic concern is that in responding to that appeal, there will be other points of detail and evidence that we wish to bring to bear. And our pragmatic concern is that in the short time available, we have a 600-page decision, hundreds of pages of judgments. It will simply not be possible in a matter of minutes to traverse each and every one of these details to understand whether they are truly respondent's notice, permission to appeal points, or things which are in practice wrapped up in Mr. Mitriu's appeal. And we're simply making a very, very straightforward, pragmatic suggestion that the issues, broadly speaking, that go to the correctness of Mr. Mitriu's appeal, including in particular the grounds under 2H2E, which traverse in some detail matters of evidence before the tribunal, we will want to be in a practical position, whether by way of respondent's notice or otherwise, in the context of an expedited appeal, to raise other matters in response to the points raised. Now, just to give your Lordships some examples of this, if we go back to my skeleton in the submissions bundle, it's in my tab 5. So your Lordships will see, for example, paragraph 9, we say the CMA's proposed appeal cannot be regarded as freestanding related to Hydrocortisone 3 only. Its arguments squarely controvert findings of Hydrocortisone 2, and we give various examples of that. Then, my Lords, over the page at 11, we say one of our points is the point Mr. Breedy raised, which is the CMA has not particularized what it says is the infringing agreement, and that is highly relevant and material to what needed to be put to the witnesses. Now, just to triangulate that onto Mr. Mitriu's skeleton, so she has a 2A, a series of points about the written agreements.
2A of what?
Of Mr. Mitriu's skeleton for today.
Skeleton for today?
Yes. Oh, sorry, her skeleton for the appeal, forgive me.
Skeleton for the appeal.
Which paragraph?
It's 2A.
My Lord, it's paragraph 92.
Well,
It starts at
92, not 2A.
92.
Ground 2A. So Mr. Mitriu has a series of points on what she says is and is not the written agreements. All I'm saying is that we will want to be in a position in July whereby what we say are the failures to particularize the distinction between the written agreements and the unwritten agreements, that we can bring those arguments to bear. And indeed, under 2B and 2C in particular, that is a fortiori, because as you will see from the headings, these are questions of evidential basis. And our pragmatic point is we will want in July to be able to bring forward responsive points of detail to this. And we do not want to be in a position whereby it is said then, well, hang on, that's a respondent's notice point, and or you should have sought PTA. we want the appeal to be dealt with in one go, in 2 or 3 days in July, and we want to avoid, in the context of expedition.
I don't understand that. I mean, either it is a respondent's notice point and you have to put a respondent's notice in, which
Yes.
you'll be given liberty to do,
Yes.
or it is not, and then if it is not, then it's and if it is a proper responsive point, then of course you'll be permitted to make it.
Yes.
But the question is, if it's not a proper responsive point, because it is a question of whether the Hydrocortisone 2 decision was correct on its face, leaving the coda out of account,
Yes.
you won't be permitted to make it.
Yes. Well,
What's wrong with that?
well, that's true. But what we want to absolutely avoid today is that we're cut off completely at the pass from even raising those points because of a truncation of what can and cannot be argued in July.
Well, I mean,
that process, in my respectful submission, needs to play out in an orderly fashion.
Well, all you're saying then is that 2.5 days should become 3.5 days, are you?
Well, not necessarily. Certainly for my part, the issues we would wish to raise in response to ground 2 in particular, we think there can be accommodation in the existing time.
You're protected, provided that nothing that happens in the July appeal results in a res judicata against you. So that you would raise anything which you think is relevant to deal with, let us say, ground 2A, errors in the treatment of the written agreement, it's either accepted or it's not accepted. If it's not accepted and Mr. Dimitri wins on that point, it simply means that on that aspect of Hydrocortisone 2, we think the tribunal did not err, always subject to appeal.
Well, my Lord,
But you don't want to be bound by anything.
Well, my Lord,
definitively. Is
my
that
Lord,
really the
well,
point?
at the very least, but in my respectful submission, the point cuts much deeper, because in adding that caveat in my submission, that exposes the very problem, because inevitably, in dealing with ground 2, the tribunal will be forced to grapple with a number of quite fundamental points of detail going to the existence of these agreements and what needed to be put. And I put it no higher than this.
We look at that purely to decide whether there was or not procedural unfairness.
Well, your Lordship's assuming there is a clear hermetic seal between that restricted exercise and the wider point going to the existence and nature of these agreements. And the submission I make today, and I put it no higher, is that there is a very, very real risk, given the way ground 2 is pleaded, that that hermetic seal is much easier stated than put into practice. And it is simply a pragmatic concern that, in my submission, in reality, it will be inevitable in dealing with ground 2, the Court of Appeal will be trespassing in quite a profound way into significant points of detail.
So if you apply for and are given permission to appeal Hydrocortisone 2, all of you, how long will those appeals, together with Mr. Dimitri's appeal, take this court, in your best estimation, bearing in mind none of that's happened yet?
Well, my Lord, I can only speak to the issues I am raising. The existing time frame of 2.5, perhaps 3.5 days is more than adequate for those purposes.
If I was granting PTO on that, I'd be looking to add another 2.5 days to the 2.5.
Well, my Lord,
Because otherwise you don't do justice to the parties.
well, my Lord, there is a balance.
That's why I said it was 4 to 5 day appeal. If you
Might
did
be
it all
more.
together, might even be longer.
Well, my Lord, there's a distinction between what I would regard some of the more metaphysical points of competition law on object and market definition. I don't think anyone is saying those will be dealt with in July, but there is a rump of points which...
But you've got, I'm sorry, I was asking for every point you're going to apply to appeal. If you also want to apply for permission to appeal the metaphysical points of
Yes.
competition law, that makes it longer, does it?
Well, in my submission on any view, they are part. That is stage 2. All I'm saying is that in stage 1, pragmatically, given the way ground 2 in particular is put, it is the least worst outcome is that anything to do with the existence of this allegedly unlawful 10 milligram agreement, that is dealt with in one go. Because the practical concern I have is that with the best will in the world, any findings going to ground 2 will, even if they are not formally res judicata, there is a very substantial risk of them trespassing on any subsequent appeal to do with the existence of the agreement. So it is a pragmatic concern. And
We're listening, Mr.
And-
Adamski. We understand what you're saying.
and given the breadth of ground 2 in particular, really it is the kitchen sink. It is every salient point going to the 10 milligram agreement. Mr. Breedy says it is not dishonesty. Dishonesty is 2E. Mr. Dimitri is forgetting 2A, B, C, and D. And you will see from our own headings points of evidence and enormous detail. And I simply do not see how pragmatically the hermetic seal between those due process findings based on those evidential issues can be segregated from points going to the existence of the agreement. So all I'm asking is that in the 2.5, 3.5 days we have in July, the points going to the existence of the alleged agreement are dealt with in one go, and I think with responsible, experienced advocates, conscious of the expedition context, that can be achieved.
Thank you. Mr. Johnson.
Well, I had the good fortune and the ill fortune to go last. I heard your disposition, as you described it earlier, as regards having 2 bites. One brief submission, if I may. And if I can I take us back to start with to ground 2A, paragraph 92, that we'd be canvassing and discussing. And the nub of my submission is this, which is that the grounds of appeal that the CMA wishes to advance are not readily separable from the respondent's notice points or appeal points that are framed identified by Ms. Ford. And that is because this appeal by the CMA is not an attempt solely and exclusively to sweep away Hydrocortisone 3. If it were, the position might be different. But the CMA's appeal squarely and directly seeks to reverse material parts of Hydrocortisone 2. So that is what ground 2A does. Ground 2A submits that there's an error, because it was never the CMA's case that the written agreements were lawful. That is a finding in Hydrocortisone 2. So what the CMA does in ground 2A is it says Hydrocortisone 2 is wrong, sets it aside on the facts. If we come down to ground 2B, if we look at paragraph 102, secondly, the tribunal misunderstood Miss Lifton's evidence. Miss Lifton's evidence is addressed substantively by the tribunal in Hydrocortisone 2. That's where the reasoning is, that's where the finding is as regards Miss Lifton's evidence, and that's why we advance the submission that our respondents' notice grounds as regards Hydrocortisone 2 sit together with the CMA's appeal, because it's not simply a question of saying the procedural fairness question, address that, set it aside. Actually, what the CMA is doing, particularly in ground 2, is also getting its teeth into Hydrocortisone 2. That's the origin of the concern.
So let's say that we listen to all that has been said on the respondent side and expedite the applications for permission to appeal Hydrocortisone 2. Is it going to be said that we then need to deal with Hydrocortisone 4 or Hydrocortisone 1 alongside dealing with 3 and 2 by anybody ever?
Certainly not by us, my lord. I don't anticipate by anybody else, because 2 and 3 form a bundle.
And 1 and
4. Separate infringement altogether. One is a
separate infringement. I'm just asking.
No, indeed. So that's the
and what's your estimate of the time that it would take to hear the appeals on 2 and 3 together as a bundle?
To hear 2 and 3 together as a bundle, my lord, 3.5 to 4 days would be sufficient, we say, because there's efficiency when it comes to opening the respondents.
There's mission creep here. It's 2.5 and then 3.5 and now 3.5 to 4. Any advance?
I'm mindful of what the court said and what others have said, but I do think there will be efficiency standing up to open the respondent's notice at that point. We do say, just in passing, that it would be, at least at this moment, a respondent's notice, because obviously one can't appeal against Hydrocortisone 2, one can only appeal against an order, and there's no operative order arising out of Hydrocortisone 2 for now.
When you say that you can't appeal an order, my lord and I heard argument last week in which the tribunal told us that we didn't need an order. And we weren't getting one.
Decisions.
So
we're told in no uncertain terms that the appeal is against the decision.
Well, my lord, I'm not advocating for that. Certainly it's true that one of the peculiarities of the Competition Appeal Tribunal is that the closing paragraphs of the judgment frequently function or set out the order. The position as regards Hydrocortisone 2, as it stands, is it's not operable. So certainly my submission would be that it would probably be a respondent's next point. That may be a theological distinction, but just I'm conscious that that's being canvassed. But the what's going to happen in July is there's going to be a detailed stepping through the factual findings in hydrocortisone 2.
I've got that point. But
Hydrocortisone 3. Yeah. And what's going to happen is then we're going to come back and do it all again.
no, we've got that point. So what I want to know is, could you get your chickens in a row, you, the respondents, get your chickens in a row by July? Orders, if you need them, applications for PTA, which you will need, and that being dealt with. Because you haven't even asked the tribunal for PTA yet, and they've said they might grant it.
So certainly, for my part, others will have to speak for themselves, we would be in a position to prepare the respondent's notice and or application for PTA, however it's characterised, and address both that point and any matters arising out of Mr. Meacher's.
In time for July.
In July.
Yeah.
I won't be, Mr. Dow will be in this case because I've got another hearing. But that's a separate.
We're proceeding today upon the basis that there's not even PTA for today. We're dealing with it at de novo jurisdiction.
Indeed.
So we can grant PTA or not, or roll something up and bring it forward of our own volition, can't we?
Indeed, my lord. My understanding is that the canvas is clean, as regards permission to appeal,
Okay.
and as regards what matters could be canvassed. And certainly, for our part, we would be prepared.
You can do it.
July, but we
Just-
need longer listening.
Just let's hear Miss Ford. You
My
can
lord,
do
we
it.
have to be ready by July. In order to respond to your lordship's query about hydrocortisone 1 and 4, we do envisage that we will seek permission to appeal hydrocortisone 1, but we do not envisage that that needs to be
Rolled
dealt
in.
at this hearing.
Okay.
Equally, we do envisage we will need to appeal hydrocortisone 4, but we don't say that that will need to be dealt with at this hearing. There are penalty points which cross over each of hydrocortisone 1, 2, 3 and 4, because they go to the overall global, what we say, disproportionate unlawfulness of the penalties. We have drawn the court's attention to the fact that there are these global points which will need to be heard at some point, and we would suggest that the time for that would be after all the liability appeals have been heard. But again, we don't suggest that that needs to be accommodated within this particular hearing.
Okay. Well, Mr. O'Donoghue's already told me he can do it, and I think Mr. Brealey has too. Mr. Meacher.
My Lord, I want to make some points in reply because we do say that the issues on our appeal are severable from the issues that the respondents wish to make in relation to Hydro 2.
Sounds like it would be messy, though.
Well, my Lord, I don't think it would be with respect, and can I explain why? The key point in Hydro 3, the procedural point, is did the CMA put its case in the decision? So its case, the CMA's case is in the decision, and the procedural question is, did the CMA put its case in the decision to the witnesses to the extent that it needed to do? So that's really the procedural point. The tribunal found it didn't, and the question for the court will be whether we're right to say that the CMA did do that. Now, my learned friends, if we can go back to our appeal skeleton argument, they focus on grounds 2A and 2B, which are at pages 56 and 57 of the court bundle behind tab 2. And it's important to understand that these subgrounds, so ground 2A and 2B, are not asking the court to grapple with hydrocortisone 2. So nothing, contrary to Mr. Johnston's submission, nothing in this skeleton argument is directed to material in hydrocortisone 2. Now, the reason we raise these sub-points, so errors in the treatment of the written agreements, is because the CMA's position is that the finding in the CMA's decision was that there was an overall consensus about the supply in exchange for non-entry into the market, a pay for delay, and that's the case that needed to be put. So
Your case, as I understand it, was there wasn't some side agreement or collateral understanding.
That's right.
That the written agreement does not contain the whole agreement. The whole agreement included all the oral discussions between Mr. Patel and whoever it was on the other side, and together with the email, Mr. Baton's email, etc. And that was the totality of the agreement.
Yes, and so you
And
need...
at various places in Hydrocortisone 2, the tribunal appear to have agreed with you.
Yes, and so
But-
we're not asking, my lord. Yes, but we're not asking in our appeal for the court to look at hydrocortisone 2 and work out whether those findings were right or wrong. What we're asking you to do is look only at hydrocortisone 3. Now, I don't want to pretend that you won't need to read hydrocortisone 2. Obviously, there is something to be said for an efficiency in hearing it all together. So I'm not trying to say that there wouldn't be any efficiencies at all. It's a balance. But we're not asking you, we're not challenging hydrocortisone 2 in our appeal. We're asking you to determine, well, what was the case in the decision and was it put? And one of the points that the tribunal finds in hydrocortisone 3 is that we didn't put some form of side agreement. And we say, well, that's not in the decision, so that didn't need to be put. It all comes back to the decision. The same with ground 2B. Now, we say here, errors in holding that the only evidential basis was the value transfer. We're not asking you at this stage, I've expressly said we're not, to go back to hydrocortisone 2 and look at all of the inferences that the tribunal drew. The reason we make this point here, and you can see it from paragraph 98, is that the only reason this point is relevant to process is because throughout hydrocortisone 3, the tribunal says, well, it was particularly important that the CMA put X, Y, and Z because the only evidence available was the inference from the value transfer. And so that heightened the need to put the points that the tribunal found that we failed to put. So it's a contextual point. And we say, well, that's not right. But we're not asking you at this stage to decide whether or not Ms. Ford's point, whether or not there was sufficient to establish an unlawful agreement in the CMA's case. We're simply asking
But you
to
accept
decide
that
the procedural
it
point.
would be at least possible to do it all together?
Yes, I do accept that. And I think there's a balance. I think it's possible to do it all together. In no way can I accept Mr. O'Donoghue's submission that this is going to take 2.5 to 3.5 days, even with all their points. And can I explain why? The first is that Mr. O'Donoghue, in his skeleton argument, says he's still considering what points he wants to take. So we don't know yet what the totality of the points are that my learned friends, that the respondents wish to take in relation to hydrocortisone 2. Ms. Ford has explained what her 2 points are, and it is therefore possible to put some time estimate on those 2 points, and I would accept that probably a day to hear those 2 points sounds reasonable. That's an additional day to the 2.5 days. Now, the difficulty with saying, oh, well, we can now decide how long this is going to take is this, that Ms. Ford says, we want to, so Auden identifies what it calls a respondent's notice point, which is that the tribunal made findings which went materially beyond the CMA's case. So Auden says that's a respondent's notice point. Well, it's not, because the Hydro 3 is only dealing with due process, and it's not a point that goes to due process. But leaving that aside and converting it into an appeal point, let's assume that Auden gets permission to appeal, to make that point in an appeal. It's of a substantively different nature, because the court will have to decide, did the tribunal go beyond the bounds of what's permissible in making findings that go beyond the decision? So we accept that the tribunal in Hydro 2 went beyond the decision. Apart from anything else, it found that Mr. Baton was dishonest, which is not a finding in the decision. So we accept that the tribunal went beyond the bounds of the decision. But as my lord, the Master of the Rolls, said, it's not impermissible for the tribunal to do that generally once it's heard the evidence in an appeal. So the question will be, did it stray impermissibly beyond the bounds of what it was entitled to do? Now, once those sorts of points are articulated by my learned friends, no doubt the CMA will want to weigh in with a respondent's notice, saying, well, even if they're right that the tribunal strayed impermissibly,
we should win anyway.
We should win anyway because of all these points
decision.
in the decision. Exactly, all of these points in the decision. So it is not possible, we say, to hear this in 3.5 days. It's a larger appeal. I think 5 days is probably the right estimate for all the Hydro 2 and Hydro 3 points, assuming.
What's the urgency about hearing this?
The urgency about hearing the CMA's appeal is that it does bear very significantly on the CMA's ongoing work in investigating Chapter 1 prohibition and in enforcing it. And the reason, my lord, that it does is because underpinning the tribunal's finding of a failure of due process and is that A, we didn't put dishonesty, and we had to put dishonesty, and B, we didn't put some form of communication, some specific form of communication to the witnesses. Now, we say we did, there'll be a debate about that, but the CMA has been proceeding for many years on the basis of very long-standing case law that in order to establish a Chapter 1 prohibition and that an agreement infringes the Chapter 1 prohibition, it is not necessary to show intention, it is not necessary to establish dishonesty, and it is not necessary to establish the precise form of the communication. Indeed, it may be impossible because most of these cases are established through inferences and through pieces of information. And so, my lord, the tribunal has found otherwise. It's a critical point in terms of the CMA's ongoing work, and that's why we say that the court's identified these dates in July. We're very grateful. We would like this point clarified. And of course we accept that if we're right, then all of these points about Hydro 2 and whether there's enough in the decision to establish an infringement, they're points which go to the substance, and they can be heard afterwards, if we're right.
Thank you. We'll take time.
My lords, can I give you one reference, please?
Yeah, yes.
This is CMA's letter supporting expeditions on page 23 of the call bundle, paragraph 19. So the CMA said, and I quote, "Tribunal's findings in due process are the only barrier to the tribunal finding a flagrant Chapter 1 infringement." That is simply not true. There will be, on any view, a realistic possibility of appeals on other issues to do with.
Well, I think we've got that point.
Mr. Dimitri's just made it absolutely plain that she's not saying you're shut up from running these points. We've got that point.
Yes.
We'll rise now. Don't go anywhere, please.
All smiles. All smiles.
Only because you're always a pleasure.
Court rise at table.
We are faced this morning with the difficult question of whether to allow the appeal by the Competition and Markets Authority, CMA, to go ahead by itself on the dates penciled in the early part of July 2024, or whether, as the respondents collectively submit, we should allow them to make their applications for permission to appeal what is known colloquially as Hydrocortisone 2, so that that appeal can be heard at the same time as the CMA's appeal from the tribunal's decision in what is colloquially known as Hydrocortisone 3. We've heard the competing positions and accept that there are merits on both sides, but it seems to us that the safest course in order to do justice as between all the parties and to make sure that points are not overlooked in dealing with Hydrocortisone 3, it will be better if any appeal that is to be allowed in relation to Hydrocortisone 2 is dealt with at the same time. Accordingly, what we intend to direct in order to hold the dates in July is that the respondents, any of the respondents who wishes to appeal the substantive decision in Hydrocortisone 2, file their application for permission to appeal within 14 days of today with this court. We direct that they also, at the same time, file any respondents' notices to the CMA's appeal in Hydrocortisone 3. That appeal, of course, is the one for which we have just this morning given permission to the CMA to appeal. The putative 4 applications for permission to appeal Hydrocortisone 2 will be dealt with at the hearing of the appeal of Hydrocortisone 3 on a rolled up basis, meaning that we will decide whether permission should be granted and go on to hear the substantive appeal at the same time as the substantive appeal in Hydrocortisone 3 at the 2.5-day hearing that has been fixed. Plainly, we have heard the creeping estimates of the time that such an appeal of both Hydrocortisone 3 and Hydrocortisone 2 will take, and we realise that 2.5 days is unlikely to be sufficient. We therefore direct that the parties attend before, well, not attend, we direct that the parties take administrative steps to fix at least 1 further day, and if possible 1.5 further days during July, or if the worst comes to the worst, September, at which we can complete the argument in the 2 appeals. I would be personally quite hopeful that 1 further day would be necessary. In looking at my own diary, it may be possible for that day to be the following Monday, which will obviously would be most preferable. Council will have to be, I'm afraid, fairly brutal about their diaries and about the possibility of juniors attending in their places if that further day or day and a half looks inconvenient for any of them, because they are thinking, for example, of travelling to sunnier climes, it being July. So that's what we intend to direct. As regards skeletons, I'm not sure that it is useful for there to be any further argument. You have Ms. Demetrio's 45-page skeleton in support of her appeal. All other defendants, against my better judgment, all other respondents, against my better judgment, will be allowed to file skeletons up to a maximum of 45 pages, notwithstanding that if there is overlap, the court will not be happy with such overlap. Please make sure that the same arguments are made in the same way in one skeleton and adopted, not made twice in different ways, just because you can't agree as to the style and approach to the particular point. Ms. Demetrio will also be at liberty to file a response to all that, again in the maximum amount of 45 pages. It's obviously a complicated and important matter. I'm going to leave you to agree an appropriate timescale for those skeletons, but all skeletons must be filed not later than 2 weeks before the hearing. I'm also going to leave you to agree or arrange with the listing office another pre-trial review to take place hopefully 2 or 3 weeks before the hearing. I think just 2 hours or an hour and a half will be sufficient for that, but I don't want the hearing to be derailed by any late points, clever or otherwise, that anybody wants to raise that might entail additional argument for which we're not prepared. So we are very keen that this will make sure that everything that is challenged in Hydrocortisone 2 and Hydrocortisone 3 comes on at the same time. And I should have said that, of course, Ms. Demetrio and CMA may also issue a notice of appeal for permission to appeal application in relation to Hydrocortisone 2, which you have not yet done as well, in the same way as the respondents. So that should cover most of the things that people have raised. We need to make an order, I think, removing the 5th group of respondents. They only want to appeal, as I understand it, Hydrocortisone 1. Nothing that I have said will prevent any party appealing in the usual course, either Hydrocortisone 1 or Hydrocortisone 4, and we will not deal with any penalty matters of any kind in the appeal against 2 and 3, appeals against 2 and 3. Now, does that, if I can put it in this colloquial way, sound like a plan, Mr. Mitria?
My Lord, it sounds like a plan, thank you. One point of clarification, please. So the 45 pages that the respondents are permitted each for their skeletons, I'm taking it that that is to include their response to our appeal plus their
It is to include everything they want to say.
Yes.
You are going to be favoured with another 45 pages, but not, you're going to have to somehow amalgamate everything if you bring a completely separate appeal. We're not having 3 sets of 45.
No, my Lord, I apprehend that we don't want to appeal Hydrocortisone 2 because it's in our favour. I think the only question will be whether we put in a respondent's notice, but we understand that any arguments will be subsumed in our 45-page application.
Yep.
You'll be at liberty to put in a respondent's notice, and you'll be at liberty to support that respondent's notice in your response skeleton. So can you all get together and agree a form of order for our approval rather than our having to do it and descend to the bear pit with all the timing and dates?
My Lord, of course.
Look very carefully, if you will. I think it's 9, 10, 11 of July at the moment. If we can all look very carefully at the possibility of, I think, 14. Okay.
Yeah,
Well,
I'll have to check my notes.
we're all going to try and do it that following week, if not the week after, if at all possible. I think 3.5 days. I think we'll try and set 4 days if we can, but I think that should be enough.
My Lord, we're very grateful to the court for expediting this.
Okay. Well, it's a pleasure to see everybody. Thank you very much.
Court